has been turned into a bungalow. There is a shed on the back of the site, and on the opposite side of the site there is a house, and beyond that there are farm buildings, and that site is quite readily enshrouded or bounded by hedgerows and trees along there. So I think, as I say, we would be looking at the actual infilling of the site, and in terms of, as special circumstances, we'd be looking at that these are the only sites that have come forward to meet the need, and it's obviously quite we've acknowledged that it is an unmet need that we'll need to provide for certainly the next 10 years and beyond. And obviously it's the way of being fair and equal to the Gypsy and Traveller community as required by the PPTS. And the fact that the call for sites, as I say, in discussions with the communities, haven't brought any alternative sites within the brownfield forward within urban areas. And obviously the nature of Gypsy and Traveller sites would tend to be that there is a slight separation required by both communities on that. In terms of Bedworth and Nuneaton, we are a very urban and high dense, I think we're probably the highest dense borough council in the county, and that means that there is limited space for this type of use within the urban edge, which, as I say, is one of the reasons why we've had to look further of these sites, and these are the only sites that have come forward. As I say, we consider that both of the sites have a brownfield nature, and as required by the PPTS, and as I say, in terms of 149, and it's the equability of providing sites for people who may actually be travelling at the time.
These points are all understood, Ms. Padbury, and they're made in the council's hearing statement, really. Okay, I mean, in terms of the way, one of the ways forward, I thought it might be worth pursuing. Well, a quick question to start with. The council states that it is currently preparing a review of its borough plan. Is that review currently proposing to redraw or to review the green belt boundary?
It isn't at the moment. It's the same policy just being brought forwards, but although we've gone through the publication, the preferred option stage, we haven't yet gone on to the publication stage, so that can be amended at this time if you require and think that is necessary. Okay.
The issue I've got, I've heard the points about paragraph 149G, and obviously if it complies with that, there's no need to demonstrate for a special circumstances application stage. But those are application stage tests, really, and whether a development is limited or whether it constitutes infilling, a judgment has to be made at application stage with the scheme before you. That's obviously not the situation we find ourselves in now. I think it isn't ideal to have a situation where very special circumstances are at least potentially required at application stage. But given the existing situation with the adopted borough plan, I think that's probably the situation we're left with. One route forward I'd thought of, or was going to suggest for discussion, for comments, was that it might be worth having something in the explanatory text beneath the site allocation. I think first things first, as a main modification, it would need to be clear, I don't think it is at present, that the sites are not being removed from Greenbelt. And then, as I say, for discussion, whether it's worth having something in the explanatory text that says something along the lines of, it's not currently possible to remove the proposed allocations from Greenbelt, or the two that are in Greenbelt, I should say, as the DPD must be consistent with the adopted borough plan, policy DS7. However, the borough plan is currently in the process of being reviewed. The Greenbelt states that these sites may be revisited, if necessary, when the borough plan is updated. I wondered if that was an approach that might be worthy of consideration. Do you have a view on that, Ms. Pepper?
Absolutely, most definitely, yes. We would be more than happy to consider that and go along with that. Okay,
I think that's the best way through. In a situation where there's seemingly two bad options, you can't. It's not an option to in terms of legal compliance to contradict the adopted plan, we have to live with the fact that very special circumstances, at least potentially, may be needed. I think that strikes me as being the best route through. If the council is agreeable to that, I'd suggest adding that to the list of main modifications. Okay. Sorry, Ms. Padbury, did you wish to come back?
Sorry, sir. We can, by the end of the day, if you would like, we have already prepared some insets showing that within our green belt. So if you're minded to, we can send that via Helen to you.
And what would that show? Sorry, that would show insets, policy maps showing the sites, insets in green belt.
It would show that the sites taken out of the green belt.
Right. I don't think we can do that at this stage for the reasons we've discussed. Really, it would be inconsistent with the adopted borough plan. So I think if you want to allocate the sites, obviously that'll need some reflection on the policies map. But I don't think insetting them in the green belt, which would be to take them out, is something that can be done, given what policy DS7 of the borough plan says.
Yeah. Sorry. No, it was just for showing you for the future what could be adopted in the emerging publication document. That was all of the borough plan.
Okay, it's probably a matter for the future plan. In all honesty, Mr. Grant, did you wish to come in? I see your hands raised.
Yes, just a brief comment, sir, which is I understood your point about the remit of the plan, which I think is the Gladman case and a couple of others. But the point that there could be a role to play in differentiating between the two greenbelt sites. Obviously, there's only one of them is outside the greenbelt, two are in the greenbelt, and so judging from your comments, you're more concerned about one site than the other. In terms of your site visits, I don't know if you planned seeing those sites, but it may be that when you make a recommendation and in terms of the way through, you might want to look at differentiating between the two sites in that respect, one being more of a candidate for review and one may be more of a candidate for actually acknowledging the sort of 149G context. I don't know if that is a point that you wanted to carry forward at all. I appreciate your policy mechanism point and your solution, but it may be that the solution is, in your mind, preferable. One solution is preferable to the other in terms of the two sites that are in the greenbelt, and it might be that some help to the authority might be of assistance going forward, bearing in mind the point about review, if you understand, sir, because it might be more difficult to demonstrate very special circumstances on one site than the other in the context of the comments that you've made. That's my only comment. Back to you, sir.
Okay. I mean, just so I'm clearly understood, when I was discussing the two sites and we were discussing whether they would meet it's the application stage test at paragraph 149G, and I was taking on board the point about limited infilling with regard to Sunrise Cottage versus the second site. I mean, I'm a little bit nervous to tread there because they're application stage tests, and I've dealt with plenty of appeals relating to each of those greenbelt tests at paragraph 149. Whether something is firstly limited, secondly infilling, are usually judgments you make with a full scheme in front of you. So I'd be a little bit nervous about going beyond or saying too much in relation to those application stage tests in the absence of scheme before me. That said, I take Ms. Padbury's point that perhaps Sunrise Cottage, that might be a slightly easier case to make than the old nursery, but again, I probably wouldn't want to go there in terms of what I say, because it's an application stage test. Unless there was something else unless I've misunderstood. I mean, is that what you were driving at, Mr. Grant?
I think ultimately that is what I'm driving at. In the long and short of it, I think that is what I'm driving at. So I think probably you've said as much as you're able to say, I suspect, in terms of the policy response in the context of what this plan can achieve. So I think the points are noted, sir, as far as we can take it now. Thank you.
Okay, thank you. I think it'd be very difficult to say anything about very special circumstances again, which is again an application stage test. Special circumstances, I think, is the plan test.
Exceptional, exceptional, isn't it? Exceptional. But I mean, and so there is a big overlap between the two in terms of them both being essentially planning judgments. But understood the point you make. So.
Okay. Okay. Just another point of clarification while we're on this matter. The council's statement refers to the Griff Wood site. As far as I was aware, that's not proposed as an allocation in this DPD. Also, presumably, is that site now fully developed out?
Yes, the county site at Griff Hollows, it is greenbelt, but it's fully built out. There's no intention of that having any new applications for it.
Okay, thank you. Okay, I think that concludes everything I wanted to ask in relation to question 2.2. Are there any further comments before we move on?
Okay. 1 second.
In which case, we'll move on to issue 2 under matter 2, which is vision and objectives and spatial strategy. I think with regard to 2.3, vision and objectives, I've got everything I need again from the hearing statements in that regard. I don't think I need to ask any further questions on that point. 2.4 relates to the relationship between policy GT2 of the DPD and policy H3 of the adopted borough plan. I've seen a council's hearing statement response to this, and I agree with the proposed approach, which is that policy H3 of the local plan should be entirely superseded. That's a lot cleaner, and it's clearly in accordance with the regs. That will mean that all references to policy H3 will need to be removed from the DPD, other than to say that it has been superseded, and obviously that needs to be explicitly set out so that there's no ambiguity in that regard. That's obviously a task for the council to undertake away from the hearing sessions. I'll not go through every instance where it's identified here. Just a minor point perhaps, but I saw that some of the proposed replacement wording in Appendix A of the council's hearing statement refers to an intention to supersede policy H3, and that's put in the future tense. I think given that obviously once the plan's adopted, assuming we get to that point, it would be then best expressed either in the present or the past tense. So is replaced, has been replaced, that sort of thing. Just on the subject of Appendix A, actually, could I request that where minor wording changes are proposed, I think that's particularly the case with the explanatory text changes that are made. Could a track changes version of that be sent to me? Because when I was going through it, it was quite difficult to pick out what changes had been made. So pages 1, 2, and 3 are largely taken up with changes to the explanatory text. So if that version could be sent through, highlighting the changes that's been made that are proposed to the existing text, you know, in the classic track changes format with strike throughs and highlighted additions, I think that'd be helpful for me to understand and pick out precisely what's been proposed for change. Thank you.
12.
Okay. With regards to questions 2.5 and 2.6 and 2.7, I'm going to take these together as they all relate to policy GT2 in the main. I also want to go through the proposed modification to policy GT2 set out in Appendix A of the Council's hearing statement. I think it's fair to say at the outset that I do think that significant modifications are required to this policy for soundness, and also to ensure that it's clear and unambiguous. What I'm going to propose we do is go through it line by line. I'll ask the council to go away and make those modifications based on the discussion that we have. I'll use the version that's in Appendix A of the council's hearing statement to start with, because obviously that includes the modifications the council have already proposed. I'd ask you to turn to that, please. Thank you. Okay. First line, planning permission will be granted for new Gypsy and traveller pitches subject to compliance with other policies of the development plan and then the following priority land uses. I think that greenbelt protection should be explicitly mentioned in this first line. It could include something like, or along the lines of, and national designations, including greenbelt, after compliance with other policies of the development plan. And the reason I think that's necessary is to be clear to applicants about the nature of the greenbelt constraint, and also given that we could potentially be moving in a direction where greenbelt is no longer subject to local plan policies, but could in fact be dealt with by national development plan policies. I know that's not with us yet, but it's something that's potentially on the horizon. I think in that context, it would be helpful to have that additional wording in to cover all bases, and also to be clear, like I say, to applicants. With regards to the 3-point hierarchy that policy sets out, as it's currently worded, this would be permissive of sites under categories 2 and 3 potentially quite soon, once the proposed allocations are developed, or where it can be shown that they're not available to the applicant. There's no link, for example, to the lack of any 5-year supply position. So say, for example, if you had a situation where all of your allocations were granted planning permission quickly after the plan's adopted and were developed out shortly thereafter, you could then be in a situation under policy GT2 where you're immediately looking at sites in categories 2 and 3. Was that the intention of the policy, firstly? Sorry, Ms. Padbury, you're on mute.
Sorry, sir. No, it wasn't the intention of it, but thank you for pointing that out. And yes, I think that needs clarification.
Okay. It's up to you how you address that. It strikes me that an obvious link for perhaps proceeding from point 1. It might well be that where you don't have a 5-year supply, or where those sites aren't. Sorry, I've just lost my place in my notes. Just give me a second. It's the problem with scrolling through Word documents. I mean, it's like I say, it's up to you how you word any modification in that regard. But like I said, I think the way it's phrased at present could lead to a very, very permissive approach to gypsies and travellers, which might not be the intention. Perhaps wording along the lines of, and again, this is a suggestion, it's up to you to formulate detailed wording, where there is a clear shortfall of pitches that existing lawful and allocated sites cannot meet, then the following sites will also be considered. Then perhaps move on to 2 and 3 there. That was my thinking, but I'll leave the detail for you. That's a suggestion only, really. But I do think if it wasn't the intention to have an almost immediate moving on to 2 and 3, then that's something that's worth thinking about. With regards to the category 1 sites, I know you said in the hearing statement that in your view that includes allocations, but when I read that, I'm not convinced it does necessarily include allocations, because it talks about existing lawful and authorised gypsy and traveller sites. Obviously, at least one of the allocations isn't an existing site, it's a proposed site. So I think for clarity, it would be necessary to include wording that, it could just say at the end of that line, for example, including sites allocated in this document. Something as simple as that would cover that point. With regards to the category 2 sites, which is land adjoining the permitted area of an existing lawful authorised gypsy and traveller site, one thing that jumped out to me about that criterion is that it doesn't have any restrictions or guidance about the size of any extensions. And so you might find yourself, or it's at least possible that you could find yourself in a scenario where you have quite a small existing site and a proposal next to it which could double or triple or quadruple its size, which might not be what you intended. That's certainly something that occurred to me. And if indeed that isn't what you intended, maybe something limiting the size, saying something perhaps in proportion might be a word, in proportion to the existing site, or some form of wording which perhaps is acts to restrain or restrict the size of any extensions might be worth considering. Did you have a view on that, Ms. Padbury? Or?
No, that's absolutely clear. Thank you. Yes.
So,
okay.
So the only suggestion, as it were, to ventilate, and perhaps at this stage, is to a proportionate is one, or of an appropriate scale, something along those proportionate or appropriate scale are the two sort of mechanisms that come to mind. Although appropriate, obviously, is a sort of becomes a bit of a overly used word potentially in these circumstances, but scale is the issue, isn't it? There, in the context of PPTS and MPPF.
Scale is the issue, definitely. I mean, I don't have a strong view on the precise wording. It's probably worth saying at this stage as well that in situations like this, where I'm making a series of comments about the detail of policy wording, what I've said when I've examined other local plans, and I'll say it here, is that if the council wishes for me to do a first draft and for me to have sight of that and provide comments, particularly when I've initiated a series of suggestions, I'm more than happy to do that if that assists with the council's approach.
Yes, please, sir. That would be appropriate.
Okay. With regards to the criteria under Part 3, and obviously a lot of these have been taken from Policy H3 of the existing borough plan. Criterion, so Part A under Criterion 3, which reads, the site must be closely linked, either spatially or functionally, to an existing settlement with an adequate range of services and facilities, should have good access to essential services, including health and education facilities, and access to local shops, or considered sustainable for other reasons. When I read that struck me as being quite stringent, particularly given that it's acknowledged that Gypsy and Traveller sites are likely to be outside the existing urban area, and that's a point made in the council's own hearing statement. And in all honesty, that's probably a stricter approach than I might take to a small-scale housing scheme in terms of assessing whether a site is accessible. So I think criteria A does need some work. One approach which struck me as potentially being a route forward would be perhaps just to remove the first two sentences, or the first two lines, I should say, of criterion A. That would just leave you with good access to essential services, including health and education facilities, and access to local shops. I think that gives sufficient wiggle room to take account of the fact that Gypsy and Traveller sites tend, on average, to be in less accessible locations because they're almost always in the open countryside or away from settlements. Does council have a view on that proposed approach?
So yeah, that seems very sensible. I think it's a point that we were picking up earlier already, sir. And one of the points that occurs to me is good is also potentially a.
Sorry, just a moment. I'm hearing some noise in the background.
Can you? I think it's probably our communications. Chris, can you make sure you're on mute, please? Oh, I can hear our IT in the background. Apologies. I think. I think he's probably taken that off now. Sorry about that.
That's fine. At least didn't say anything particularly embarrassing, so it's he wasn't insulting any of us by name, so I'll take that as a bonus.
So there's always a worry there. My only suggestion, sir, is a really helpful point you've just made, is that other than the good as an adjective in sustainability and accessibility terms might not be as helpful as in the context you've just described as reasonable, given the way in which Gypsy sites may be distinguishable from small scale residential sites, as you've just indicated. So good access, good as a sort of an adjective for the purposes of planning might not be as helpful as reasonable, in the sense of providing the level of proximity to the or maybe public transport sort of issues that underpins that. I don't know, sir, if you I think the point that you made about the first part of it is very clear and very helpful, but the question about whether good is the right adjective is the point that I raise back to you, sir, as it were, as a dialogue.
I can see that reasonable would be would be preferable. I mean, again, with this one, I'm happy for the council to go away and formulate the wording it sees fit, and to comment on that later. I can certainly see the merit in that suggestion of using reasonable rather than good, or some other form of wording, Mr. Grant. And like I say, I'm happy for the council to go away and use the approach it considers best, and to comment on that at a later stage. Just one other question as well with regards to criterion A, because we talked about the accessibility element. The last part, which says or considered sustainable for other reasons. Now, the word sustainable is another of those words, which can mean anything. Well, it can mean a number of things. It's usually used in the context of the framework to you reach a view on. Let's just see exactly. It used to be paragraph 6 of the framework. See if it still is.
8, sir.
8. Oh, there you go. That's the definition of sustainable development, which in effect means it's economic, social, and environmental objectives, and you can usually find along one of those axes something to describe something as sustainable. So I was just a little bit worried in terms of clarity with regard to that latter part of the criterion. I mean, what were the sort of situations the council were envisaging might trigger the use of that part of the policy wording?
So we were minded, obviously, in terms of sustainability. The sustainability appraisal mentioned in there that there would be minor impacts due to the distances. There wasn't necessarily walking distances from the site, but it was our interpretation that, as you quite rightly state, sir, that economics, the social objectives, and the environmental objectives are within that policy anyway, so that they would, in this instance, override on the actual walking distances. So in terms of economics, we'd be looking at sufficient land of the right type and the right type to the right time to support the growth.
I understand those points, but it's specifically in relation to criterion, or that part A of criterion 3. And that latter section, which says, so obviously you have the section which talks about access to services and facilities, and then it says, or the site is considered sustainable for other reasons at the end. So in other words, if the site's not accessible or has poor accessibility, then where it's considered sustainable for other reasons, you might. I mean, I think my nervousness comes from 2 points really. So I'll just finish the thought, and then I'll come back to Mr. Grunt really. One is I've dealt with a large number of planning appeals, probably well north of 500, and most are described as sustainable by the applicants, as you might well imagine, in one form or another. Secondly, and this comes from dealing with Gypsy and Traveller Section 78 appeals, it's very often the case that people will put forward personal circumstances or some other form of arguments to justify departure from the development plan. And that comes back to the approach which we all know in planning, that if there are material considerations that dictate a departure from the development plan, that can be done without a clause being inserted in the development plan almost anticipating it. So that's where I'm coming from really, and I'm happy to hear a comment back, and I'm sorry, Mr. Grant, for cutting across you.
No, sir, it was very helpful to hear your thought completed. I think more helpful to my client than hearing what I had to say, which is really a short point, which is that other circumstances in this context might include co-location, which doesn't qualify specifically within the earlier part of the co-location criterion in 1 and 2. So it might be that there are other good reasons because of the proximity of the similar land use, which would mean that in sustainability terms, or shared trips and all these sorts of other things that could come into play from the point of view of accessibility, they might not qualify as being on or adjacent to, but they might be very close to an existing site as a co-location, and it might be therefore there is a higher level of sustainability and accessibility terms for that reason. But your point, sir, is taken, which is sustainable for other reasons is too wide-ranging in the context of the criterion, and I think that point is taken away as a helpful marker.
Okay. Thank you, Mr. Grant. I'll leave those thoughts with the council then, and to consider in rewriting that criterion. And as I say, I'm happy to comment on any revised criterion that's produced as a result of that.
Thank you.
Okay. Criterion B. I was a little unclear as to the meaning of this. Could the council just explain what this criterion is intending to achieve, just to start the discussion, please? Thank you.
It was down to the same as the MPPF in terms of scale. In other words, if the site is, say, if there is another proposed site and it has 10 pitches at the moment, we obviously wouldn't be looking at, in terms of scale, that another 15 was provided on there. But I appreciate what you're saying, that it's difficult how that could be interpreted.
I think it's the word relative that maybe I'm being overly picky. It's in proportion might be better. I mean, we discussed the wording before.
So I take your point. I mean, I think the point there is that you've got B and C, and in the sense they're sort of serving similar masters within the two criterion. So the number of pitches or plots relative to the size and scale of the site is in part related to density, isn't it, and standard of the pitch size.
Okay.
And part C is relative to the size and density of the surrounding community. But obviously the number of pitches relative to the size and scale of the site is a relevant criterion, because you wouldn't want to have an unduly non-dense development, for example, or an overly dense development, and it would be a question of trying to pick that up within a satisfactory criterion.
Okay. I think what I didn't like about it was the use of the word relative. So the number of pitches or plots is relative to the size and scale of the site. Well, relativity is it's imprecise, to say the least. I don't particularly like it in the next one either. I think for clarity and precision, I get exactly what you're trying to achieve, and that's helpful clarification. Obviously, you want efficient use of sites. You want them to be, the number of plots to be as you described. I don't like the use of the word relative. In proportion might be better. I'll leave that with you. With regards to C, which we touched on as well, I think my concern is with that is the use of surrounding settled community. Perhaps that should be nearest settled community, because surrounding implies you have a site in the middle of a community or within a community. I think the PPTS does use the term nearest settled community.
It's very helpful. Thank you.
Thank you.
Criterion H, which is over the page on Annex A. It's the second part of this policy I've got an issue with, really. So up to the first line and a half, concluding at the comma, is fine. And neighbouring uses will not be affected by air or noise pollution as a result of the Gypsy and Traveller development. I have concerns with, because to me that reads as implying that Gypsy and Traveller pitches are by nature disruptive or noisy uses, which they're residential in nature. And that could be read, I'm not saying this was the intention, but that could be read or interpreted as being somewhat discriminatory.
Yeah.
Again, I'm not saying that was the intention, but for that reason, I think criterion H after the comma needs to be deleted. Okay. Those are my comments on policy GT2. As I've said before, I'm more than happy to have a slight of a revised copy and to give comments back on that.
That's fine, thank you, sir.
Okay, we'll move on to issue 3 then, under matter 2, which is the need for Gypsy and Traveller pitches. 2.8 is the evidence base supporting the identified need for residential pitches and travelling show people robust, taking into account factors such as existing provision, household growth, migration, hidden need, etc. The Council's hearing statement was helpful and provided some useful clarification, so thank you for that. Just a few follow-up questions from me. The calculation of need in the first 5 years of the assessment period includes an assumption about in-migration. However, after the first 5 years, the calculation of need is based solely on household formation, with no allowance for migration. What's the reason for that approach, please? Thank you.
Good morning, sir. Michael Bullock here from ARC4. Very good question, and it's a good one to pose. The way that the modelling has worked, and bearing in mind that the PPTS is silent on how Gypsy travel accommodation assessments are carried out, and the only recourse we have is the old is the former guidance, which has been redacted. So it has been incumbent on researchers to work through reasonable methods for understanding need. Now, in the past, what I used to do was look at need in like 5-year tranches of time. So what you would do is you'd have a look at all the dynamics affecting need in the first 5 years and then just apply them for subsequent periods. But through challenge, through development in method, that trailed away to looking at 2 types of analysis, if you like. The first type of analysis is to understand the short-term dynamics of housing need, and that is to look at in detail all the different flows of households in and out of a local authority area, level of household formation, etc., to give us a short-term view. But then in the longer term, what we don't know is whether those trends will continue or not. And what we do have to appreciate is that sometimes families are incredibly dynamic, and because you're dealing with a small population, it can be quite challenging to look at those kind of intricate trends over a much longer time horizon. So what we do is to say we look at the evidence in 2 parts. First of all, short term, incredibly detailed. And then in the longer term, which is 5+ years, we then focus on the likely level of household growth due to demographic factors. So what we do is we look at the detailed information we have on households and their composition, and then work through what does that mean when those children reach 18? What does it mean in terms of the actual demand for pitches going forward? So that's done. That approach has been tested at examination on a number of occasions. I think what's fair to say is that it's a reasonable approach, and it's certainly an approach that I know a number of other organisations do as well. And there's a particular, so really in the longer term, there is a focus on the likely level of household growth. In the shorter term, we're looking at a lot more detail because we're able to extract that information from people, but it's more difficult, I would say, to extrapolate that over a longer time horizon.
Okay.
But I have to say that is actually a very helpful question, actually, because it does. I think the main point is there's a different emphasis in the shorter term modelling and the longer term modelling.
So in your view, it's too uncertain to be projecting migration in the long term. That's the approach?
Yeah, I would say so, because because one of the real challenges of this is of doing GTA research is because of the really small numbers of people that you're working with. I mean, having done work in Nuneaton and Bedworth before, it was really so familiar with the area, and I think, as you'll note from the GTA, we got excellent response from the community. We got well over 80, I think it was 88% response. So I mean, we got extremely good engagement from the communities when we did the study, which sets the scene. I mean, as I say, we have had this approach examined on numerous occasions, and it's been seen to be a reasonable approach to be taken. What I did try and do. What I did do in lockdown was I worked with the Planning Advisory Service to make a range of recommendations around how to assess need, and this is one of the factors that we discussed at workshops as part of that particular study as well.
Okay, I understand the point about it being difficult to project current trends into the long term, but assuming in effect zero net migration, you are making an assumption about the longer term, just that it will be zero in net terms.
You are. I mean, I think one of the interesting points that again, it's about reasonableness, because when you're looking at the big driver generally in any community is household growth through children. That's children forming households when they reach 18. That is the key driver in most of the GTAs that I've I've worked on. But yes, you're right. What we're saying is that there are different approaches to the method in the longer term, which is much more based on demographics and household growth.
Okay, thank you.
Thanks.
The assessment estimates that 5.3% of households currently in bricks and mortar housing would prefer to live on a Gypsy and Traveller site.
Yeah.
It states that this approach is based on national ARC studies.
Yeah.
Could you describe to me what those studies entail, please, and
Yes,
why you consider them to be robust?
Certainly. I mean, essentially, we've managed to speak over the years. We've managed to speak to about 380 households living in bricks and mortar accommodation, and that's basically what we're talking about in terms of the ARC4 national evidence. So on the evidence that we got from bricks and mortar households, virtually everyone to stay where they were. But there are small numbers within those households, either the households themselves or folks within those households that wanted to move on to a pitch. So we've used that metric for a number of years now. Interestingly, one of the main, I've also had representations from some of the planning agents who, again, think that is actually a reasonable position to take. I think the big challenge is, if it's fair to say, one of the biggest challenges is actually understanding the actual number of people in bricks and mortar accommodation, and that is a real challenge. I mean, we've got the census to work from, which is what we do by default because it's an official public source. But what we are finding, though, is that actually the trend seems to be changing, so that actually the flow is increasingly from sites into bricks and mortar rather than the other way around, which we're starting. I've done a recent study up in Yorkshire and the Humber, where we actually found quite considerable numbers of people wanting to move from a site to bricks and mortar. So that was more of an exception, but we are seeing a trend of more people wanting to move from sites to bricks and mortar within this general context.
Just so I understand the figure of 5.3%.
Yeah.
That comes from, if I understand what you've said correctly, the studies you've done nationally and elsewhere.
Yeah.
I presume that's a live data set as you update your studies.
It is. Yeah.
It gets updated. And where you've dealt with Gypsy and Travellers who are living in bricks and mortar housing, that on average is the proportion that wish to return to to move to a
correct
to a site. Okay.
Correct. Yeah.
Clarification.
Yeah.
Thank you.
Thanks.
So let me catch my notes. So if I look this way, it's because I'm writing notes.
No, that's fine. No, don't worry. That's okay. Don't worry.
Okay, thank you. The assessment states, one thing I picked up, the assessment states that no concealed or doubled up households were identified. But it also states that a significant proportion of respondents said that their pitch was overcrowded.
Yeah.
What's the reason for those two findings? Are they?
Yes.
Is there any contradiction there?
No, there isn't. And the reason there's no contradiction is that very often you may well have quite large family units living on a particular pitch. And just to backtrack ever so slightly, one of the things that we have to understand is the relationship between pitches, caravans and households. And to do that, I personally go around and do site observation work. And through that, I can start to understand the dynamics of people living on pitches. That is also followed up when we're actually doing the interviews and we're asking people, whether there's anybody else that lives on a particular pitch. So in terms of the definitions for this, so basically a concealed household could be, say, you've got a couple with 3 children. The 4th child has recently got married and wants their own pitch. That arguably could be a concealed household. So, but in the analysis, we take a judgment as to whether that is a concealed household or whether we take it as a new household that wants to form. It could be either definition. Households that are so I think the point being that we're really, really careful to first of all ask people whether they think they're concealed or doubled up, and then secondly, we make sure in the modelling that wherever it's appropriate, the need is recognised. So that's concealed. When it comes to doubled up, that's where you've got 2 completely independent family units living on the same pitch. Now that does happen, but we again through our site observation, through the work that we do, we confirm whether that is genuinely the case, or whether in fact it could be, say, a family member that wants to move off and is set up as a new household, and it's covered in that way. But to be what we do certainly found in Nuneaton and Bedworth, the issue of doubling up wasn't really identified through observation or through what people told us. And then finally, overcrowding. Now that can result from all of the previous, whether it's doubled up or concealed, but it can simply be a large family unit living within a caravan or in two caravans. So overcrowding in itself could be a function of the actual family size rather than an intrinsic need for additional pitches. If anything, what overcrowding probably results in is a need for a larger pitch rather than the pitch that somebody is on at the moment. So
okay, so it's multi-generational families, it's large numbers of children living together by choice as a single household.
Absolutely. And these are all the nuances and the judgments. Sorry to interrupt there, but these are all the nuances and the judgments that we take as professional researchers working extensively with the communities. Crucially for me, if there is a need emerging from that family unit, I want to make sure that need is recognised, and that's where that's certainly where the short-term modelling kicks in.
Okay, thank you. That's helpful clarification.
Thanks.
One final question on the methodology. The assumed supply of pitches includes an allowance for turnover.
Yes.
And my question was to what extent that was a genuine source of new supply, given that the households who vacate those pitches will presumably need to move to a pitch elsewhere. I mean, that approach wouldn't be taken in bricks and mortar housing, for example. You wouldn't allow an allowance for new supply arriving from houses being sold or being vacated by renters. So what's the distinction between why is there a different approach for Egyptian traveller pitches?
Okay, good question. Well, I think there's two things. First of all, reference to turnover as part of supply. But what I would put back to you though is when we're looking at affordable housing need and we're going through the PPG looking at how we assess affordable need, we do take into account relets as part of that modelling. So we understand what the overall need is for affordable housing, but as part of that modelling we look at the potential supply coming through relets as part of that modelling. So really it's a similar kind of method that we use with the Gypsy and Traveller work, because what I do know is that there is supply, there's potential for people to move onto pitches over any given time period, and I see this time and time again around the country. And if we didn't include an allowance for turnover on pitches, then I think that would it doesn't sufficiently take into account the supply that's coming forward. Because what we do know is that pitches do get vacated because people move off, they go out, and I take your point. People will move elsewhere, or they'll move, or they'll die, or they'll go into bricks and mortar. We get a sense of what that pattern is. We also get a sense of whether people have been able to move onto a pitch because it was vacant, or whether they moved onto a pitch and someone was there already. We look at all these different dynamics. But what I do want to do in part of the modelling is understand that there is potential supply of pitches over a period of time by those becoming vacant, just as we would do if we're looking at affordable housing. In the context of Nuneaton and Bedworth, there's the Griff site, which is the one where we only look, I should hasten to add, we only look at turnover on local authority or county council sites or housing association sites, because we know that is where we've got accurate data on who's moving, and also there is a degree of control of how those pitches are then reoccupied and reallocated. So what we've assumed in the GTAA is, based on past trends of mobility and management records, that a turnover about 1.4 pitches per annum is expected. since the GTAA, what we've found actually is in COVID times it went down to just over 1, but then last year the latest data would be it was 2.5 pitches became available. So, or at least at the average over the year. So the point is that over the last 2 years, the actual number of pitches becoming available has actually gone up from what we assumed in the original GTAA. So what that is saying is that there continues to be supply of potential of people moving on to pitches, which just reiterates the importance of recognising that as part of the need in a specific local authority area.
I suppose the question came from turnover doesn't affect the total supply or total pool of pitches available in an area. And I take the point with regards to affordable housing calculations. Could it not be argued that inevitably people, perhaps to improve their situation, might not need affordable housing anymore and might be able to afford market housing? There's a separate pool of accommodation for people in affordable housing to move into. They might move into the private rented sector, for example. Yeah. And is that so? Does that analogy hold true for Gypsy and Traveller pitches, where you don't have the same, unless it's based on people who do move into bricks and mortar housing, or people who pass away? Is that what it's fundamentally rooted in? That's what I'm trying to get to the bottom of, really. Yeah. Because that wouldn't be accepted in housing supply terms for bricks and mortar housing. I'm talking in global housing supply terms, in a local plan approach. Houses for sale or houses available for rent would never be factored into supply. You've made the analogy with affordable housing, but aren't people in affordable housing, don't they have other pools of supply to move into? Whereas turnover, does it affect the total pool of sites? It doesn't seem that it does. So why should it be counted as something to be netted off supply? That's what I'm trying to get at. Really.
I like this line of inquiry, actually. In terms of, I think what you have to differentiate is the overall supply of physical pitches in a locality compared with the actual capacity of those pitches to accommodate households. They're two slightly different things. And I would still maintain that if you look at it from that point of view, there will be, so one pitch may accommodate 2 or 3 households in a 5-year period. The other analogy I would extend, though, is that you actually get, it is known that families will move from, say, a local authority pitch onto their own private site. That does happen as well, and I've got, there's examples around the country where that has happened. So we do know that there are dynamics at play which result in those pitches becoming available for local residents to occupy them. And we've looked at this. The reason I'm confident about this is we've looked at it in some incredible detail in Shropshire, where there's a number of local authority sites there, and there's incredibly detailed records kept of the dynamics of who's moving on, who's moving off, and that's recently been examined, although we're waiting on the outcome. But the discussion there was that we've got really solid evidence of the fact that capacity is generated through people moving off pitches, which allows other families to move on. And very interesting in the Shropshire example was that most people moving onto sites are coming from outside the local authority area, which arguably would suggest that the actual needs from existing communities either are not emerging as we expected them to, or people are making the choice of not going onto local authority sites in that particular context. So there is a precedent, if you like, for assessing. I know it is a controversial area, but there is a logic behind understanding that there is that sense of one pitch could accommodate a number of households over time, which has been reflected in the modelling.
Okay. Well, thank you for that clarification, Mr. Bullock. It's been helpful for me, certainly.
Good. Yeah, but so they were helpful questions to me as well to think about. Yeah.
Okay, that concludes my questions for 2.8. I'm going to move on to 2.9 now. which has the same methodology been used in both the 2016 and 2021 assessments. There's one question in particular I wanted to ask as a follow-up to what was in the hearing statement. And it relates to transit pitches mainly. The 2016 study found the need for 5 transit pitches and included quite a detailed analysis in respect of those. Why was a different approach taken in the 2021 study?
Yeah, in terms of the actual evidence base, we actually got, probably not quite as good data as we'd got in 2016, but we got a sense of how many unauthorised encampments had been taking place, bearing in mind that there is an injunction that's been in operation since 2019 that doesn't allow any temporary stopping within the boundaries of the borough. So, to be fair, the policy position has shifted quite dramatically. So therefore, the number of unauthorised encampments, because of that injunction, have gone down quite dramatically. I would also say as well that there's been quite a shift in perspective on how unauthorised encampments should be managed. In the past, there was a drive to look at developing transit provision for families as they're travelling through a local authority area. But there are nationally, there's only about 350 to 380 transit pitches anyway. It's a very, very small level of provision. And what we do know where they operate is there can be challenges in management, operation of them, etc. So broadly, what we're finding nationally is a shift in emphasis from a dedicated site where people travelling through a local authority area can be accommodated to a much more flexible approach. And this was pioneered by Leeds Gypsy and Traveller Exchange based in Yorkshire. And what they started to do with Leeds City Council was introduce negotiated stopping, which was basically the local authority would have a range of areas that it could direct people to if they were travelling through, introduce a mechanism whereby they were supported in what has worked incredibly well.
You froze for a second. Nick. You just sorry to stop you. You froze for a second there. I didn't catch what you said for about 4 or 5 seconds. Could you just?
I can do. Yeah.
We were at Leeds, sorry, and the approach there back then.
Yeah. So Leeds Gypsy Traveller Exchange pioneered this concept of negotiated stopping, and it is now being widely adopted by local authorities as a flexible approach to meet the short-term needs of people travelling through a local authority area. And that has really gained traction. There's a lot of interest in it now. Local authorities tending to adopt that approach. So in effect, when a family is travelling through a local authority area, and certainly I do know that Nuneaton and Bedworth still support people that need some kind of emergency support and stay somewhere, they can be directed to a number of locations where they can stay for a short period of time, subject to conditions set by the local authority, and then move on again. That is developing as the kind of general norm, if you like, as to how unauthorised encampments are managed, which kind of plays down the traditional sense of having a dedicated site where people would go to. And what we know in the wider North Warwickshire context is there is still an interest in developing a site somewhere. But what I've recommended to Nuneaton and Bedworth specifically is that they should be focusing on negotiated stopping as a way of meeting those short-term needs, in line with the way that national perspectives have shifted since 2016. Excuse me.
You mentioned there, Mr. Bullock, that it was becoming the position that councils would have 2 or 3 locations where they could direct someone who needed temporary stopping to.
Yeah.
How does that differ from a transit site? Because obviously a transit site is precisely that. It's the area that's dedicated. It's an identified area that's where people are directed to for temporary stays. Yeah. So how does a negotiated stopping place? that's dedicated. If there are 2 or 3 areas reserved
Yeah.
for that purpose, it appears to be dedicated from how you described it. How would that differ in practical terms from a transit site?
I think in practical terms, you have to think about where transit sites are located. And they're very often located in not very nice areas. And a lot of the feedback we get from communities is we don't want to go and sit in a lay-by on an industrial estate or under a pylon somewhere. We just want a bit of green space that we can be on. And that is, I'm not saying that all transit sites are like that, but listening to communities, they welcome the flexibility of being able to stop over somewhere, bearing in mind a lot of families got young kids. They don't want to necessarily be in a heavily industrialized or urbanized area, which is very often where traditional transit sites are located. What this is about is finding reasonable spaces that people can stay for a short period of time. Additionally, what you do find is that number of caravans on unauthorised encampments tends to be low. I mean, most of the ones we recognise when we're doing our research is probably less than 3. It's usually small family units travelling, but you do get spikes of activity, for instance, for funerals or for weddings, where you do get much higher numbers. So even if you've got a particular site, it may not be big enough to accommodate the short-term needs that are being evidenced. And one of the things that we do suggest is where local authorities already have transit sites, to keep them, but also to have negotiated stopping in addition to that, to help meet those much wider, larger needs that can occur from time to time. So I get the point around having a dedicated site. I think what we're recommending to councils, not Nuneaton, but for other areas as well, just have a more flexible approach using a wider range of localities, so that they're much better tailored to the particular sizes of groups that are travelling through an area.
Okay, just let me close my blind, by the way. The sun's starting to shine on me. Apologies.
Lucky you.
This won't be a problem later in the afternoon and once the
Yeah.
sun's come round, but first thing in the morning, I'm often lit up like a Christmas tree by the morning sun. So, okay. I think the way the discussion's going probably leads quite neatly into questions 2.10 and 2.11, which relate to the justification for not allocating a transit pitch, assumptions about transit pitches in neighbouring areas, and the arrangements for stopover places. I think we'll move on to those questions now, really. An objection was received to the DPD by North Warwickshire Borough Council at Regulation 19 stage in relation to assumptions being made about the use of the Oldbury Road emergency stopping slot. Has that objection now been resolved from the council's perspective?
I'll defer to Jackie to answer that one.
Okay, thank you, sir. The way I actually read the wording, it wasn't an objection. It was just they had concerns if we were minded to that site. That is a Warwickshire County Council site, so there is a provision there for all the northern boroughs within the area. However, we tend not to put people towards that site at the moment because it's not in an appropriate area. And there has been a high level activity of vandalism in the area as well, when the site isn't actually used. So no, we're not taking that transit site as read as being one of our sites.
And that's a traditional transit site, is it, rather than one of the more flexible arrangements Mr. Bullock was describing?
Yeah, when I say transit site, sorry, there was a recent appeal that North Warwickshire had, and the inspector actually mentioned that site, and I think the original intention was that it was classed as a transit site, but the inspector queried that, and I would tend to say, given the circumstances of where the site is and what it provides, it's more of a negotiated stopping area as opposed to an actual transit site.
I think it'd be helpful for me if a clear distinction is drawn between what a transit site and a negotiated stopping site is, because we've had the description about location and what a traditional transit site might have been, say, as Mr. Bullock was describing, perhaps on the edge of an industrial area or in a very urban setting. But obviously, I presume a transit site would usually be an allocation in a local plan, and it would usually require planning permission. Is a negotiated stopping site not in that category in planning terms? So what's the planning distinction, firstly? And secondly, what's the distinction in terms of the facility it provides? It'd just be helpful to clarify in my own mind precisely why there's such a dividing line drawn between the two. Thank you. From either Ms. Padbury or Mr. Bullock.
I mean, if I can start, sir. I mean, I think this is one of the what you might call grey area, and what we do know is that planning policy is quite clear that local authorities need to meet their residential and transit needs. However, as I say, there has been this marked shift in how transit need is met. You know, historically,
I understand. I understand that shift. You've described it very clearly. It's described to me clearly what the differences between the two types of site are. Firstly, in planning terms, and secondly, in physical terms. How would I distinguish one from another if there were two side by side?
I think in terms of a transit site, you would have hard standing. You would have, in terms of the physical layout, you'd have hard standing. You'd have perhaps a shower block. You'd have electricity supply, that kind of thing, but it would be a hard standing setup. Whereas with negotiated stopping, what you would have is a much more flexible approach. So things like portaloos, water, refuse collection would be brought to the folks at the negotiated stopping area, but it wouldn't necessarily be a hard standing. It may be, it may not be. It could be a hard standing. It could be a field. It could be some kind of car park somewhere. I think the point being, it's a flexible approach which doesn't often sit neatly with the distinction of a specific area that would be allocated, if you like. So it's a slightly
it might be different sites from month to month, year to year. It might be that in year one a council thinks sites A, B, and C.
Yeah.
In year two, it's sites D, E, and F, and
correct.
And so and presumably they don't require planning permission. Is that another distinguishing feature?
As far as I'm concerned, no, that it wouldn't. It's a case of having that land available. Jackie, so you want to come in further?
No, it was just my interpretation between the two that the transit site is, I was just about to contradict you, Michael, sorry, that a transit site would be more of a permanent use. It would be a material change of use. So in my interpretation, yes, it would require a planning application, whereas some of the negotiated sites, if no formal change of use has been on the site and they're just used for a maximum of 30 days a year, then it wouldn't necessarily require a full planning application.
Okay, that's helpful clarification. Thank you both in that regard. Okay, so what's the council doing to work with other Warwickshire authorities to establish a coordinated response to the delivery of appropriate temporary options? Because that's a recommendation of the GTAA. Or the assessment, I should say.
Michael, do you want me to jump in on that?
Yes, please.
We do have an apologies in the MIQs. I referred to it as a monthly meeting of all the local authorities, including the police liaison officer as well. It's actually a quarterly meeting. They do have a protocol that they all meet, that they have all signed to as well, but those quarterly meetings are basically working a way of just in terms of the knowledge base of sites what's ever happened, but also moving forwards for providing this negotiated sites as a sort of a county red as opposed to just individual sites. So just making sure that we all work to the same practices.
Okay. Presumably such sites tend to be local authority owned. Is that the case?
They would tend to be, but Michael may confirm that you can get negotiated sites that may not be council owned, but I would have thought in most cases they are.
Indeed. I mean, because one of the things, I think, again, just as a bit of background, when we're doing our GTA work, we've very much got an eye on how need can be being met, and we actively discuss with communities whether there's any potential for some kind of temporary stopover provision that can be made available. As an example, I'm working with a family at the moment who have got land, who want to work with the local authority to provide some kind of temporary stopover provision. So we do know that there are other ways of meeting it from support within the communities as well.
Okay, and have stopover sites such as have been described have been agreed so far in the borough as part of this new approach, or is this something that will be taking place going forward, or is it something that's taking place at present?
I think that would have to be as part of this DPD that would be looking going forwards. At the moment, it tends to be of a borough-wide that it's more, I don't like the word, but it's a tolerated site of 24, 48 hours sometimes, if it's a site that isn't causing unnecessary harm or nuisance. But I think that would be something that we would have to look at, as I say, as part of this DPD.
But it's an approach. So it's an approach that is being explored rather than one that's in operation in effect. I mean, I guess that in response to the point about the DPD, before you answer on the first point, if these sites don't require planning permission, they don't operate effectively outside of the planning system, and therefore the DPDs would be unrelated to them.
We have used negotiated stopping in the past. There was one particular family that the child was requiring cancer treatment, so we do have a negotiated an agreement that the families are required to sign. Well, we both sign. It's a legal agreement, and within that there are the protocols of how the site will be left and what provision that we will provide to them as well, in terms of refuse, perhaps portaloos, etc. And also there would normally be a bond on that of £100. So it has worked, but as I say, it's not commonly, it's not a common thing that we use.
Okay, thank you, that's been helpful. Unless there are any final comments, I think I'll move on now to, I'll move on to 2.12. I think with regards to 2.12, I've got everything I need from the hearing statements on 2.12. Are there any comments before we move on then from matter 2? Okay.
So my only comment is would that be an appropriate moment for a very short break?
You read my mind, Mr. Grant. I was seeing it was 10:59. That was my very next suggestion. It is an opportune moment. It's always nice to finish at such a neat and clean point, having concluded a matter. We are making good progress. I'd say now I'd be very surprised indeed if we needed to use the reserve day tomorrow. Obviously, we'll see how things go, but it's 11 o'clock, so I'm going to suggest we break for half an hour, and we'll come back at 11:30. At that point, we'll move on to matter 3, which is the site allocations. So thank you all for your contributions so far, and we'll resume at 11:30. Thank you.
Thanks.
Thank you, sir. Chris, can you
everyone. It's now 11:30 and time to resume the hearing sessions for the Nuneaton and Bedworth Gypsy and Traveller site allocations DPD. We concluded on matters 1 and 2 before the break, so that just leaves matters 3 and 4 to pick up now. With regards to question 3.1, which has a rigorous search been undertaken to identify all potential sources of Gypsy and Traveller sites. The Council's hearing statement was very helpful in this regard, so thank you. I just had one follow-up question in relation to that point, which is, were council-owned sites considered at all when identifying potential allocations? Thank you.
Certainly from my point of view, sir, yes, we have been looking at those. I'd need to clarify with Michael in terms of what he was looking at in his search, but yes, we would have gone through that.
Okay, so council-owned land in and around the borough was considered as a potential source of supply for new sites, though?
Yes, we would have, yes.
Yes. Okay. That's the only question I had under 3.1. 3.2 was how a proposed intensification opportunity is identified. Is their current use as Gypsy and Traveller sites lawful? I think the point about lawfulness is addressed in the hearing statement. I think for me it'd be helpful to start with if one of the council's representatives, Ms Padbury or Mr Bullock as appropriate, could set out precisely how the intensification opportunities were identified, whether they were put forward by the site owner, and if so, in what context. Thank you.
I'll pick that up. I'll pick that up first, sir. As part of I think I mentioned earlier that when we're doing our GTAs, it's not just understanding need, it's understanding how that need can be met. And one of the things we ask of site owners is whether or not their sites can be either intensified or extended. And we often get quite a lot of positive feedback from people who are quite keen to do that. So the first protocol is to, when we're doing the interview, well, first of all, either through site observation or through the interviews themselves, we identify whether additional pitches can be brought forward onto sites, and then think about how many there could possibly be. That is then, and then for Nuneaton and Bedworth, there's a further commission to then look at what the opportunities would look like for those individual sites, which are subject to a separate document. So in effect, we identified where things could be, where additional capacity could be created, and then followed that through with some further work.
And what level of commitment was expressed by the site owners towards delivering those sites, particularly the intensification opportunities?
Yeah, it's generally very positive. Very often people say, "Oh, I'm not necessarily exclusively for Nuneaton and Bedworth, but people are very often keen to want to engage with the local authority to increase capacities on their pitches, on their sites, I should say. This is very much a case of, if there is capacity and are you interested? That's the kind of level at which we then started to engage in some more detail. So these are actually real, genuine opportunities to increase provision through either intensification or expansion of sites.
Why is there nothing in writing from the owners committing to these allocations?
Again, I'd have to defer to Jackie on that one.
Ms Badbury, did you wish to comment on that point?
I'm assuming, Michael, that these were gentlemen's agreement that were made on site when you actually went out within the sites. Yeah.
I mean, there's no. One thing you have to bear in mind is when you're working with Gypsy Traveller communities, the formality can be an issue. So if you start saying, "Oh, you need to sign here to do that," it will not go down very well at all. So this is very much around, again, a softly approach of understanding whether capacities could be increased, and then working with the local authority to bring those forward.
Mr. Grant.
So I was going to make a similar sort of point, which is that plainly looking at deliverability, as it were, as a direct proxy or to house building in the settled housing community wouldn't necessarily be appropriate because of the very different nature of the way in which sites, as you will recognise from dealing with a number of 78s, no doubt, as you've already acknowledged, come forward for this particular land use. So whilst you might readily have written evidence from a house builder or developer or a land promoter about delivery on the record, the same sort of evidence trail wouldn't necessarily follow in this particular land use simply because of the particular land use that you're concerned with. Now, whether that will change over time, we don't know, but the current situation is consistent with the sort of evidence that one would see potentially at 78, and also reflects on the sort of engagement that you're getting, sir, for this exercise we're currently engaged with, which is very different than the sort of commitment that you're getting for promoting sites or opposing sites from the settled community. It is a different exercise, therefore their expectation for evidence must be proportionate and relative to the land use. That's what I would say.
Okay, thank you. Do the owners of these intensification sites, presumably they're aware that the sites are proposed to be allocated and have a new planning status? Is that the case? Sorry, you're on mute, Ms. Padbury.
Sorry, sir. I haven't had any discussions direct, but I would assume my predecessor would have done that at the consultation stage.
Just to add to that, I mean, in terms of the discussions we had with people, that was the intention, to explore what could be done. So there was a general understanding that this was about trying to work with those folks who had potential site options that to be considered by the council. So there would be an expectation that once this work is done, that the council would continue that relationship with the owners to bring forward new sites or new pictures. Sorry.
And those owners both expressed to you, and when I say both, I mean the two intensification sites, so GTSA 1, Sunrise Cottage, and GTSA 3, Winter Oak. They both expressed to you directly, Mr. Bullock, that they wish to bring those sites forward for intensification purposes, not merely in the hypothetical as, oh, we could do that one day, but we intend to do that.
Oh yeah, genuine interest. I mean, I do know in particular, talking to one of the owners who was really keen to bring things forward and was very keen. So yeah, there is that understanding. Once people, because what we often find is when we're doing the site observation work, very often people come to say, "Oh, I've been wanting to put in permission to put another caravan on here," and I'm often seen as that go between the individual and the council. So this is all done in a spirit of positivity about increasing provision, and people are very much aware of that when we do this further work.
Okay, Ms. Padbury, did you wish to come in?
Thank you. As a part of that, within Michael's teams, one of Michael's colleagues would have actually gone out after Michael had from the surveys and actually carried out site assessments in terms of looking at the amount of pitches and looking at the pitches. So there would have been that dialogue at that time as well with the owners.
Okay. Did any timescales for these sites emerge from those discussions then? I mean, are these considered to be short-term or medium-term opportunities?
I think in terms, I'm looking at short. I'm looking within the next 5 years. So that's what the site assessment paper is focusing on. It's looking at whether there's some additional provision that could be brought forward within the first 5 years, which is obviously in line with PPTS.
When was that made explicit through the questionnaire and the questions you put to the owners? These you were looking explicitly for short-term options. Was that put to them in those terms?
I think I would expect it would have been, because that was the brief that was given, and I think the point is that very often communities want to work immediately, and so we're not looking at some potential provision down the line. The principle is that you've identified that you could do something now, and this is what we're taking forward. So implicitly, we will be looking at bringing these changes forward within 5 years.
When it comes to intensification opportunities in particular, what comfort do you have that those opportunities would be made available to gypsies and travellers generally, rather than just, say, to family members of the owners of the sites?
I think that depends, and this is one of the very interesting areas around planning for gypsies and travellers, and the actual nuances of communities, how they interact, etc., is not necessarily part of the PPTS, but we know implicitly that there can be issues with different groups not being able to go onto different sites. Now, I think the general point I do want to make is that I know from one of the sites, I will not, because we're in a public arena, I won't talk about the particular site, but I do know one of the sites that we spoke about, there was quite a lot of mobility anyway, because it had been used as sort of temporary accommodation for families coming and going. So I think for that particular one, it would probably be open to a wider range of people, although I can't guarantee that will be the case, but the premise would be that it'd be widely open. For other sites, very often it's about actually meeting the needs that we've already identified. So for some sites, there may already be an emerging need from a young family member who wants to remain on the site, and that's a way of actually trying to meet some of the immediate need for families. But I think it's fair to say there can be no guarantee that all need can necessarily be met by all the new pitches coming forward, because there will be degrees of nuance around who can actually move on to those particular pitches.
Okay, thank you. That's been a helpful clarification for me. That's all the questions I had to ask under 3.2. And with regards to 3.3, we've probably covered everything under the two preceding questions. Matter 3, issue 2 are the proposed allocations and policy requirements. I don't have many questions to raise in relation to issue 2, as we've either covered those points already, or I've got all I need from the statements. So rather than go through questions 3.4 to 3.8 one at a time, I probably prefer to just go through each site in line, and we'll deal with any outstanding matters in that order, if that's okay. We'll start with site GTSA 1, which is Sunrise Cottage, one of the intensification opportunities. Just one question on this with regards to the policy wording. Given the site is largely hard-standing at present, what's the reason for requiring a preliminary ecological assessment in the policy wording? Thank you.
Part of that would be that it would be a requirement for any planning application bringing a site forwards. It's actually in our open space SPD that is done as a minimum, but we would recognise, with the nature of a site being hard standing, that would be considered at the time, and the view would be taken of what extent the preliminary review would be taken at. It might be a case of it isn't provided because photographs are provided showing that the site is just hard standing.
Okay, so it's an SPD requirement in effect.
It's an SPD requirement.
Standard approach. Okay, that's helpful clarification. Thank you. With regards to GTSA 2, which is the old nursery site, it's the site that isn't an intensification opportunity. I understand this site was promoted through the GTAA process by a local gypsy or traveller. Do you have any indications with regards to this site as the timescale for bringing it forward? Thank you.
Michael, have you got anything from discussions with the landowner?
Just bear with me a second. I'll just double check. you just remind me of the particular site, please?
Right,
The
it
old
was,
nursery.
yeah, GTSA 2. I mean, I picked up from the documents that in discussions with local gypsies and travellers, this site had been mentioned to you as one that was owned by a local resident and who wished to bring it forward for a new gypsy and travel site.
I'm just opening up another file.
So in that discussion,
I do apologise. I haven't got the actual other file open at the moment. So which particular sites are we talking about?
The old nursery.
The old nursery, so GTSA 2, it's the one that isn't an intensification opportunity.
Okay. I mean, there's nothing. I mean, I suppose. I mean, again, it's the same principle of when we're talking. Let's have a quick look. I've got some notes here. It just says present the site is abandoned, although the owner secured gates, etc. Just reading now. Site actually, there's 2 entrances there. Plenty of open space. Given the rural, there's just a general comment really in the notes. We've had discussions with the owner.
Sorry, Mr. Bullock,
as a viable opportunity for revenue provision. Sorry, is it my internet? Sorry,
I lost your audio for a second there, Mr. Bullock. I do apologise. There was a
sorry,
glitch on the line. And I missed about 3 or 4 seconds of what you said. Could you just go through that again, please? Sorry.
Yeah, I was just saying when the visit had been made to that particular site, it was currently being used, and there was nothing specific about. All we know is that the owner was happy to take forward, and they'd be happy to provide up to 5 to 6 pitches. He's not looking to overdevelop the land, but there was nothing specific about when that would be brought forward. But again, the implicit assumption is that what we're looking at is a site that could be brought forward within the first 5 years. That is certainly my understanding of when we're doing this work. That's in our mind, and that's certainly at the forefront of the document we've produced to say that we're looking at potential options within the first 5 years.
Okay, thank you. Mr. Grant, did you wish to make a comment? Sorry, Mr. Grant, you're on mute.
Sorry, I'm going to the top of the list now of the muting problems. I apologise for that, sir. Most of that's covered by the supplemental comments from Mr. Bullock, but I was going to suggest that if it was helpful to you, sir, we could provide you with a note if that is necessary. But it strikes me that maybe there's nothing to be gained if Mr. Bullock has provided all the detail he can. Initially, I wasn't sure that the research was producing everything that Mr. Bullock was able to, and what I was keen to ensure was that you got all the information that you wanted to have on that, sir. That's all.
Okay, thank you. I think I'm okay without a note, in all honesty. I think Mr. Bullock's response covered what I needed to hear, really. So I don't think another notes are necessary at this stage. Okay, detailed point on this site. The first criterion of the policy wording requires the closure of the northern access. What's the reason for that, please?
So it's in terms of visibility. The southern access is better in terms of visibility. Also, Warwickshire County Council highways don't like 2 accesses to a particular site. They consider that is a highway safety issue.
Okay, thank you. That's helpful. In Appendix A of the Council's hearing statement, there was another criterion that was proposed to be added to this policy, and that's on page 5 of Appendix A, straight after the numbered points. So it says add to the criteria for GTSA 2, the old nursery, and it's quite a if the council's environmental health team has asked for that to be added, I can understand the need for something along those lines. It just struck me that in the context of a policy that's very concise in its wording, that putting in a bullet point of that length, which contains a lot of unnecessary detail, perhaps there was scope to quite radically trim it. It could simply say, for example, address any contamination at the site. I think that would obviously then trigger a requirement, presumably for a phase 1 assessment application stage. I don't think as much, also requiring that they consult with the environmental health team. That's really for the council to do at application stage. So for me, I've no problem with the principle of something along those lines, but I just prefer it to be very short and simple to say, address any contamination at the site.
Thank you, sir. It was more of an indication, just to remind my development management colleagues, as and when the site comes in, that that needs to be considered along the lines with the previous planning application at the site.
Okay. Yeah, I mean, it does read as a note to DM colleagues, really. But like I say, I think if the policy wording could just say address any contamination at the site, that would be more appropriate. Okay, that's all I had on all the points I wish to raise on GTSA 2. With regards to GTSA 3, which is the Winter Oak site, which is the one non-greenbelt site to the north of the borough. There's a separate document, in addition to Appendix A to the Council's hearing statement. There's a separate document on the examination library. It's document CD 1.9, which is entitled Recommended Minor Modifications, which sets out some additional changes which aren't in Appendix A. With regards to the Winter Oak site, I think it proposes 2 further bullet points. I'll just call those up for my own reference point, actually. Yes. Okay, so the first of which says it is suggested prior to any submission of a plan application, the applicant's contact National Highways. And the second one relates to air quality and noise assessment, and that says may be required. Now, to my mind, both of those read as being advisory in nature. Really, it's saying it almost along the lines of it would be a good idea if you might want to consider this, neither of which really lend themselves to being policy requirements. So I think if the council wished to insert those into the text of the DPD, the best place to do that would be the explanatory text. If it's merely as a signpost, which I think it is, then that's the explanatory text rather than the policy wording. I am instinctively uncomfortable with policy wording that requires consultation with external bodies or the approval of external bodies. In any case, not that the policy wording does that here. But yeah, I don't think those 2 bullet points belong in the policy wording itself. I've got no issue with them being put as a signpost in the explanatory text then. On the subject of document CD 1.9, which is the one I've just referred to, the recommended minor modifications, it also recommends 3 additional bullet points relating to water that would be applied to each of the 3 allocations. I think with regards to the third of those, which is the longest, that again is a signpost, and it shouldn't be in the policy wording itself. I don't have a problem with it being an explanatory text. If you wish to flag that up at any stage before applications are submitted, fine. With regards to the first 2 bullet points, it strikes me that there's scope to condense and combine those into a single bullet point. I'll leave the wording to you, and again, I'm happy to comment on that. I don't think it needs to reference Severn Trent water, for example. It could just say your picture should connect to the existing foul drains. Where this is not possible, the impact on the water environment should be considered. Something as brief as that, and that's off the top of my head. You might formulate far better wording when you've got time to give it further consideration. So I think that's my preference, to combine those into a single bullet point, combine and condense, and remove reference to Severn Trent water, because they don't have a planning. It's not their job to determine the planning application or to have a bearing on it, really, other than as a consultee to the council as local planning authority. Okay. Any thoughts or response on those comments, or are you happy with those?
Thank you, sir. They were more of an explanatory note, and it's likely, well, I know they would be covered by conditions anyway when the planning applications were brought forwards.
Okay. Okay, thank you. That covers questions 3.4 to 3.8 for me. With regards to 3.9, again, the council's hearing statement is helpful in terms of the clarifications it provides. Just wanted to discuss the wording for policy GT4 under this question, particularly the second paragraph. It's only a 2-paragraph policy. This currently states alternative uses will be permitted if it is proven that either there is no longer a requirement for travelling show people accommodation or that an alternative site is available within Warwickshire. Now, my reading of that second clause really is that it would allow the site to be lost if it could be shown that there's just another site in Warwickshire, which is quite a big geographical area. Presumably that wasn't what was intended. Ms. Padbury.
I think the reasoning behind why it stated Warwickshire in that is because it's only one of a kind within the Warwickshire area. It is an individual site that isn't seen anywhere else.
Okay. But would it be acceptable to be lost? Would its loss be acceptable if just a single pitch elsewhere in Warwickshire, even if it was at the other end of Warwickshire? I'm aware we're right at the northern, or towards the northern end here. If a single pitch elsewhere was provided within the entire Warwickshire area, would its loss automatically be acceptable?
At the moment, we've got shown evidence that for some years only one of the plots has actually been used, but there is a likely chance that a second plot will be required, extended by family. So I don't think we'd be looking just for one extra plot in other areas of Warwickshire.
So if 2 plots elsewhere were provided, would this site would it be okay to lose this site?
I think again it would be down to demonstrable need for this type of use.
Okay. I think if that's the case, I mean, the concern when I read this, and like I say, I deal with an awful lot of Section 78 as well. I'm not just a local plans inspector, and so as you might imagine, the precise meaning of policy wording comes up rather often, and what a policy does or does not mean, or how it should or should not be interpreted, is a frequent bugbear. My concern was, and the reason for the questions, is that in my reading of that second paragraph, it occurred to me that if you can just show there's an alternative site somewhere else, the site can go, and that might not be the council's intention. If it isn't the council's intention, then you could reword it to strengthen it, to say something along the lines of alternative uses will only be permitted, and I think only is an important word to include, if it is clearly demonstrated that the site is no longer required for travelling show people accommodation. Something along those lines would be stronger and would just avoid a situation where loose policy wording results in a site being lost that you might not intend to be lost. Something to mull over, and again, I'm happy to have a look at any revised policy wording if that is of assistance.
No,
I just leave that with you if it's okay.
Yep.
Okay.
Yeah. And I think just a general point there, sir, in terms of that particular showman's yard, it's been there since the 1930s, if not possibly even longer than that. It's the only one in Warwickshire, and I was when I was doing the research, I was acutely aware that it's unique in Warwickshire, and therefore it was important to safeguard the land use for travelling show people. So that was the kind of backstory to why further work was put forward and why a policy position has been developed.
Okay. Well, I'll leave those thoughts for the council then. You've heard my suggestions, and like I say, happy to have a look at any revised policy if that's of assistance to you. Okay. Issue 4 is supply of pitches over the plan period. I think with regards to issue 4, I've probably covered questions 310 and 311 already in the discussions we've had regarding delivery timescales. With regards to 312, which is about windfall sites coming forward, and the rate at which they have to come forward, I should say. The table provided in the hearing statement was very helpful, so thank you for that. I also saw that a windfall application has recently been approved for 3 pitches. Presumably that's an additional contribution to the supply in the 5-year period then of 3. Is that correct?
That is correct, yeah.
Okay. Which just leads us on to matter 4, which is the final matter, which means we'll wrap up before lunch, unless monitoring takes far longer than I assume it will do. Okay, I think with regards to matter 4 and the 3 questions I've posed, it'd probably be best if we go through the indicators in table 3 line by line and deal with it that way. I also want to use the proposed revised version in Appendix A, the council statement, for that discussion. So if everyone could turn to that, please, that would be helpful. Thank you. Okay, just with regards to the first indicator against policy GT1, it struck me that that first indicator is really a less detailed version of the indicator for policy GT3. In effect, it's measuring the same thing but with less of a fine grain. Is that a fair observation, or is there a nuance I've missed there?
No, that's fine.
I mean, in effect it seeks to deliver 11 pitches. Obviously, that's the plan's aim, but the indicator against policy GT3 is the same but more detailed and provides the breakdown by 5 years and beyond 5 years. I think if there isn't anything added by that first indicator, I think it's, well, I don't think it adds anything, the first one. So my suggestion would be it should be deleted, unless there's any strong views to the contrary.
No, that's fine. So
okay, so that one should be removed. With regards to the indicator for GT2, there's no timescale in that target to grant permission for all the allocated sites. Is that something the council considered at all in formulating this table?
no, I don't think it was, although I think that should be, in essence, that should be probably added to the actual monitoring, which is what I think you're referring to.
Yeah, I mean, I think my question for this, which is question, let's go back to it. Quite a few questions, let me just find it. Yeah, so are they clearly time related such that they can be monitored during the plan period rather than at the end of it? That was the relevant question, really, I think. I think it would be helpful if there is some sort of monitoring. If there is a target attached, I'm open to suggestions on when that should be, whether it should be after 5 years that you want permission on these sites granted, or whether a slightly longer timeline. But I think a timescale is more helpful than just 100%, because 100% by when? By the end of the plan period? Well, the reality is by then it's likely to have been reviewed anyway. And if you're looking at these targets to help inform whether a review is necessary, I think it does make sense that there is a time period attached to that target. I'm happy for the council to go away and think about what that should be, but I do think it needs it. Purely as a detailed point as well, I think it'd be better to say allocated sites permitted in accordance with the policy rather than just sites, just for total clarity as well. Okay. And again, happy to review any revised target there. Mr. Grant.
Just a very short point, sir. I agree with your point entirely in relation to the 11 additional residential pitches. I wondered whether there was any need for any amendment in relation to the first 6 additional pitches, because obviously that's the early part of the period, and it's talking about available for use but for 2025-26, so that actually that is in itself providing a sort of timescale over which those would be intended to become forward. If it's only in relation to the 11, then I understand your point, sir.
Okay, so in effect, you're saying the timescale is provided in the next. I suppose it is. I suppose it is. I mean, I suppose the only disjuncture there would be, obviously we've had 3 windfalls approved recently. Gets you halfway to the 6, which is obviously a nice bonus when these things arrive. I'll take that point, actually. I'll take that point. Perhaps that provides you with the timescales, the necessary timescales already. In which case, perhaps you don't need the target, a date attached to the target of 100%, because the timing point is addressed below in effect. Okay. Okay, fair comment. Final point on GT forward indicator. Just find the wording I was looking at. Here it is. I don't like the word proven. I prefer demonstrated, if that's okay. It might come across as a detailed point, but proven. I think demonstrated is superior. Okay, that concludes my comments on the monitoring framework, and indeed concludes my questions for the hearing session in their totality. Are there any final points the council wishes to raise before I move to close?
No, sir. Just maybe in terms of the closing remarks, it would be really useful to have maybe a collection of understandings as to what it is that and over what timescale that we can provide you with the information that you have requested through the hearing process, or whether you would be intending to record those in any event. Of course, the team will go away and provide a schedule of proposals. And what I had in mind, so just to sort of flag up, and we just discussed it in the adjournment, was maybe that there would be a schedule, but in addition to a schedule, there would be a track change version which would be underlined in red up to and prior to the date of the hearings, and then underlined in blue in relation to those changes that are in response to the hearings, so that you would have, in a ready, recognisable fashion, the document as originally constructed, and the modifications on an original track change version, and then a further revised track change version which picked up any modifications proposed as a result of the hearings, and then also a schedule that provided you with that material. But I just wanted to check that as an approach, you were happy with that approach, or whether there was anything, as it were, additional that you'd want to see done.
I think that a document of that nature would be very helpful to me, definitely. I suppose just to ensure, though, that the first round, I think it was the blue you highlighted, pre-hearings changes, that doesn't include things that we've discussed and I've asked to be taken out. That would be my only comment in that regard. But definitely a two rounds of track changes would be very helpful for me to sort of see how the documents evolve and to compare it with the original. And I definitely appreciate that, and thank you for the suggestion. With regards to the mods and the actions arising from today, what would be helpful for me is I've asked the council at the start to keep a note of those. If you could just write that note up in bullet point form and send it to the programme officer, and I'll combine that with mine, and we'll agree a final list of actions and mods, just so we're all clear, and we can do that perhaps fairly short turnaround. That'd be very helpful. In terms of obviously, I've got quite a lot to consider after today's discussion, and I'll need to go away and reflect on some of that. I can write in due course with regards to the next steps towards the examination. That's how I'd seen it panning out, really. So, list of mods as the council sees it to the programme officer. I'll supplement that or change it in accordance with the list I've got. The double track changed copy of the plan would be very helpful. And obviously I'll come back to the council in due course with regards to some of the outstanding matters and the way forward. Okay, well, thank you all for your time today. This is a personal best for me in a local plan examination to be concluded by 12:10. I'm on 6 weeks in counting in Greater Norwich, so it's a refreshing change in that regard. But, thank you all. It's been much appreciated. The hearing is now closed. Thank you.
Thanks.
Thank you, sir. Chris, can